All right, let's dive into a neighborhood dispute that took a really strange turn. Picture this. You've got a fight over a gorgeous mountain view, a pretty stubborn homeowners association, and then a formal legal hearing that happens after the whole problem was supposedly solved. It's a weird procedural puzzle, and trust me, the answer is surprisingly important for any homeowner out there.
It just doesn't make sense on the surface, does it? You fight your HOA, they suddenly cave and give you everything you asked for, but you still have to show up for a hearing. The reason why this happened, well, it reveals a huge lesson about what it really means to win one of these fights.
So, what was this all about in the first place? Well, at its heart, this was a classic neighborhood showdown. One homeowner's protected view against their neighbor's brand new pergola.
Okay, so on one side, you've got Fern and Judith Hedges. They bought a home specifically labeled a view lot because they wanted to see the beautiful Santa Rita Mountains. But on the other side, you have their HOA, which, a little while back, approved a neighbor's plan to build a pergola that would, you guessed it, block that exact view. You can already see where this is going, right? A collision course was set from the get-go.
And look, this wasn't just about what they preferred. It was literally in the contract. Their community's governing document, the CC&Rs, had this exact line in it. I mean, it doesn't get much clearer than that. An unobstructed view shall be maintained. So the homeowners had the rules squarely on their side.
So how did this escalate from a simple disagreement to a full-blown legal challenge? Well, like most of us would, they didn't start by calling up lawyers. They started by just trying to talk it out.
So, back in late 2019, they tried the friendly neighborly route, but that went nowhere. A month later, the HOA officially doubles down. They send a letter saying, nope, we stand by our original approval. The homeowners are at a dead end, so what do? 6 months later, they took the next logical step. They filed a formal petition with the state.
So you have to wonder, why was the HOA digging in its heels so hard? Well, their arguments were something else. First, they said the previous owners didn't complain back in 2018. Then they argued that, hey, a perfectly unobstructed view is impossible on that street anyway. And a personal favorite is this one. They claim that to fix this one view, you'd have to tear down 8 other houses. It really feels like they were just throwing stuff at the wall to see what would stick.
But this is where the story takes its big twist. After months of saying no, the second this dispute became official, the HOA's entire argument just crumbled.
That's right. For 7 straight months, the answer was a firm no. But as soon as a formal petition landed with the state's Department of Real Estate, it took the HOA board just 1 month to do a complete 180.
I mean, look at this. The change is just night and day. Before the petition, the HOA story was, we were right, the decision stands. After the petition, their story completely changes to, oops, that approval was an error, we've taken it back, so this whole case should just be dismissed. They just completely folded.
Which brings us right back to our central mystery. The HOA rescinded the approval. They admitted they made a mistake. The neighbor was even set to take the pergola down. The homeowners got exactly what they wanted. So why on earth did everyone still have to show up for a formal hearing almost 3 months later?
Okay, let's solve this puzzle. The answer is all in the legal definition of what it actually means to win a case like this. And believe me, it's not as straightforward as you might think.
The key to this entire story is this legal term right here, prevailing party. This concept is so important. It basically means that even if the problem you're fighting over just vanishes, a court can still look back and decide who the real winner was. And the winner is the side whose legal action caused the other side to change its mind and fix the problem.
And here it is, the crucial point. The judge looked at the timeline and saw that the HOA only reversed its decision after the homeowners filed that official petition. That petition was the direct cause of the resolution, and that's what made Fern and Hedges the legal winners, the prevailing party, even though the pergola issue was already solved.
So why does this prevailing party status matter so much? Why go through all that trouble for a hearing? Well, it all comes down to this number. In Arizona, the law is pretty clear. If you are the prevailing party in an HOA dispute, the other side has to pay you back for the cost of filing the case.
When you look at the final order from the judge, it all clicks into place. The pergola removal, the judge called it moot. It was already handled. A civil penalty, the judge said no, not warranted here. But the filing fee, yes. The homeowners were awarded their $500 back. That is why the hearing had to happen, to legally determine who the prevailing party was, and to officially order that repayment.
Now, this isn't just some quirky story about one neighborhood. It's packed with powerful lessons for anyone who lives in a community with an HOA.
So what can we all learn from this? First and foremost, read your rules. Those CC&Rs are a binding contract. Second, document absolutely everything. But the biggest lesson here is that procedure is power. Friendly requests can be ignored, but a formal, documented process forces a real response. And finally, a win isn't always some big, dramatic courtroom moment. Sometimes the real victory is simply forcing the other side to follow the rules, and getting your filing feedback is the legal proof that you were the one who made it happen.
And that really just leaves us with one final thought. This whole saga started with a single sentence buried deep in a thick legal document. It really makes you wonder, doesn't it, what rights or even restrictions might be hidden in your own HOA rules. Thanks so much for tuning in.